Hello, everyone. My name is Chris Wickman. I am on the board of directors of the Ingham County Bar Association. Thank you so much for being here today for this event on Zoom Advocacy. We are extremely happy to have the Honorable Judge James Jamo as presenting, as well as Jessica Zimbelman. Obviously, Judge Jamo is a wonderful judge on our local circuit court bench after many years in practice, so he's bringing both perspectives. Ms. Zimbelman is also on the board of directors for the Ingham County Bar Association and is a assistant defender at the State Appellate Defenders Organization, handling criminal appeals as well as trial motions and things like that. Because this is a short session, I will keep it short. Any questions, please put them in the chat or message me privately and I will break them in with the judges. There is a handout you'll all be receiving and I'll be sending that in the chat momentarily. So I will thank our presenters once again and turn it over to them. Thank you very much.
Good afternoon, everyone. Thank you for being here, as Chris indicated, for our Zoom advocacy program. I think it is pretty universally agreed that video conference hearings are here to stay. The pandemic pushed us here, but I think it's without dispute that on some level, for certain types of court proceedings, we're going to have video conference hearings with us into the future. And therefore, the more proficient that all of us are, both as judges and as litigators at using it, the more efficiency we can accomplish and probably better outcomes for your clients. First thing that I want to talk about is not directly Zoom or video conference advocacy, but it is so related. I want to touch upon this, and it's been a source of challenge in Ingham County in our circuit court, and that is that during the pandemic, we have, through the court clerk's office, have accommodated email, receiving pleadings by email. And I want to point out to everybody that the difference between emailing your pleadings to the court clerk and electronic filing. MCR 1.109G controls electronic filing, and it's defined in that provision as a system provided by the State Court Administrative Office that permits electronic transmission of data and documents. That is not what Ingham County has currently. We're on our way there. I don't know a time frame as to when we will get there. Other courts, other circuit courts in the state are there, or at least in pilot programs. And because we are not an electronic filing court, even though you can email to the court clerk during the pandemic, 2.119A2D still applies, and that is, except where electronic filing has been implemented, a copy of a motion or response and any briefing filed under the rule must be provided by counsel to the office of the judge hearing the motion. We've had a lot of confusion about this because people think because they can email pleadings that they are electronically filing and therefore do not need to provide judges' copies. We still need paper judges' copies that get to the judges' chambers. And so contact whichever judge is hearing your case to make sure you accomplish that. And along with that, Judge Stokes has pointed out to me she would like to make sure that in advance of hearing she receives proposed orders. And I'll talk a little bit more about how to handle exhibits and other documents. But I wanted to point that out because people get on, attorneys are getting on the Zoom or video conference hearings, and they haven't assured that the judge actually has their pleading that they're going to work from, and that's, of course, something you want to avoid. I want to then get into the advocacy part of it itself, and Jessica is going to talk more about some of the technical aspects. I'll touch on a couple of them, and she has some great examples in the handout materials, and she'll talk about them. But I call this part, the first part of this presentation, don't set your hair on fire. We have all tried to use virtual backgrounds, and because people are working from all different locations, I tend to prefer to be in the courtroom as I am now and not have a virtual background. But not all virtual backgrounds are of the same quality or caliber. And what you see sometimes, and I see, is that if somebody has a certain virtual background and they move their head, now with me it's not a problem because I have no hair. But for those of you who have hair, your hair flames out to the side. So that's what I call setting your hair on fire. So check your virtual background and see how it actually performs when you're presenting. Some of the virtual backgrounds, in addition to making you kind of flame out to the side as you move, some of them turn you into a ghost, and you have sort of a image, an outline image, but it looks ghost-like. So it really does depend and is helpful to determine how good your virtual background is, because it's terribly distracting to the judge when these things are going on because of your background, and the judge is trying to pay attention to your argument. Also, I would advise counsel to counsel their clients about backgrounds and movement during presentation. There is far too much of clients walking around their house, talking to other people while the hearing is going on, texting or doing something else that the judge can see on the screen and is distracting from your argument. So you could emphasize with your clients that it's not helpful to their case if they are doing those kinds of things. Also, one of the things that is a real temptation for people I see, and I understand this, but it is something you should probably try to avoid, and that is, don't use the video screen as a mirror. People get on the screen, they're in the middle of argument, or they're listening to the other side present argument, and they start doing their hair or adjusting something or other. So use a mirror before you get on, and it'll be less distracting for the court when you present. In addition, one of the things that I am surprised is still a bit of a challenge for some attorneys at this stage of us all having done this for several months now, is the concept that you are in court. And that what that means is you should dress and act professionally. We still have attorneys who don't dress appropriately, not many, but some. We have attorneys who show up in t-shirts for court hearings, or are somewhat dressed appropriately, business casual, so to speak, but don't have a tie on or a jacket. It happened just yesterday in a hearing that I had, an attorney appearing with an open collar. You wouldn't walk into the courtroom and do that. And so keep in mind that what you would not do if you were in person in the courtroom, you should not be doing either dress or presentation wise when you are on a video conference call. So keep that in mind. Along with that, it seems that we've all become very comfortable with having hearings from our office or from our home or wherever you may be. And sometimes that's a little too much comfort. I have lawyers sometimes who are leaned way back, laying back in their easy chair or their office chair while they're making their presentation. It is extremely distracting from the content of the argument. It's not appropriate because it is, again, a court proceeding. And so keep those things in mind. Also, don't set yourself on fire orally either, not only visually, but orally. And that is just because you are remote and it is easier for people, for example, in a phone call. We all know that it's easier for people to say things to others in a phone call and in a manner that they wouldn't do it if they were in person. So just keep in mind, it is as if you are in person in the courtroom. Don't change your approach or what you would say or demeanor towards the court or towards the other litigants just because you are remotely presenting. Further, speak slowly. The court reporter needs to get everything that is down. The court reporter is often remote even from the judge. For example, in my courtroom, my court reporter is not in person here when I'm in person. And keep in mind that there are often delays of the video transmission. So if you speak slowly, it's easier for everyone. It's easier to avoid speaking over one another. One of the tips that Judge Stokes provided to me to pass along is if you are somebody who is tempted to cut into the other side's argument, or it is one of those heated types of motions, put yourself on mute to help control that and wait your turn to speak, because it's that much harder to create a record remotely than it is it's hard enough in the courtroom with everybody live and people speak over each other. It's compounded by the video conference. The next thing I want to touch upon is exhibits and demonstrative aids. Think about ahead of time how you are going to present these things in court. Sometimes you don't think about it and you're ready in an evidentiary hearing. I actually have had this happen where the lawyer in an evidentiary hearing remotely said to the witness, "Let me hand you exhibit whatever." And then she stopped and said, "Oh, I guess I can't hand you exhibit whatever." That was earlier in the process in terms of us all getting used to it. But you can see how that's a natural tendency based on our training and what we're used to. So work out ahead of time how you're going to present exhibits, whether it's going to be through screen sharing or some other, and Jessica's going to talk a bit about screen sharing in a moment. But think about how you're going to do it. What I prefer, what we've worked out with my court reporter, at least we have to this point in time that's worked pretty well, is if you email to our court reporter the proposed exhibit, he or she can then mark the exhibit, send it back to you, and can keep, as the court reporter, keep that marked document. So if it's actually admitted during the hearing, then the court reporter actually has it to keep as part of the record if the transcript is going to be produced. So that's one way to do it. Another thing about approach, Jessica's going to talk a lot about how you come across on the screen, lighting, things like that to think about, and pitfalls to avoid. But one that Judge Dragonchuk brought up and has suggested perhaps would be a good one to pass along is if you are using a webcam separate from your laptop or tablet or whatever you're using to have the video conference on, if you're using a separate webcam, attach it to the top of your computer screen, or have it in such a way that when you are looking at the screen, you are also in sync with the webcam in terms of what is being shown. Judge Dragonchuk had an experience recently where the entire time the lawyer had their head turned towards what they were looking at as they were watching the screen, and the webcam was pointed at the side of the lawyer's head. And Judge Dragonchuk spent a considerable part of the argument distracted by wondering why the lawyer was mad at her and wouldn't look at her. And so keep in mind how you come across, and if you're using multiple devices to do the streaming, try to keep that in mind as to what part of the camera is looking at you. The next thing that I want to talk about, and again, this will be something that Jessica will talk about more in the technical part of the presentation when she gets to that, and that is consider making life more simplified in terms of the video conference for either the court or the law clerk. In my case, Casey Smith operates for me for the most part the moving people in and out of the meetings and into meeting rooms and so forth, or if the judge is doing it, making life easier for the judge. Consider joining the meeting with the correct name and teaching your clients how to change their screen name. We need to know who is in the waiting room, who is the real person in the waiting room, what is their real name, and so learn how to change your name or adjust that on your Zoom profile as you enter into the waiting room. It's never good when your client joins the hearing using a street name that suggests that they're into the criminal activity with which they're actually charged. I see a little bit of that happen with clients, so I suggest you counsel your client as to adjusting to their actual name if they're using a device separate from your location when they come into the hearing. Again, Jessica will talk a little bit more about that. Know how to use breakout rooms. Again, we'll cover some more of this below, but get familiar with the breakout room concept and the prompts that are provided through Zoom for breakouts. If anyone else comes into your breakout room when you're talking with your client, of course, stop talking so we can get that sorted out if the person doesn't belong in the room. Know how to leave the breakout room, stay in the breakout room, usually until you're directed or there's an agreement to come back into the hearing. Sometimes the clerk has to move people around. My law clerk may move people around without notice, and clients should be counseled ahead of time to be patient if they're just in a breakout room by themselves. And be careful when you return to the main hearing. When you leave the breakout room, be careful to just leave the breakout room and not to leave the entire meeting, which removes you from the hearing altogether. That happens occasionally, so it's important to become familiar with the breakout rooms and the prompts as well. In addition, for live streaming, one of the things that is really, I think, useful with regard to these video conference hearings is the ability to stream. Many of us are public access, creating public access different ways. Most of us, I think, are using YouTube in some form. Mine is live streamed on YouTube. And so keep in mind that if we're live streaming the hearing, when there is a break, typically, unless we tell you otherwise, it is still live streaming. So be mindful of that. Be mindful of the fact that we can see and hear what you are doing, unless you put your video on pause and you mute your microphone, that you are still not only visible to the court, but you, if we're live streaming, you're visible to everybody that is watching. Again, it is a benefit of video conference is it provides pretty unbelievable court access. I had a hearing in a case where we had several hundred people watching the hearing. On a good day, I don't know, I guess I can get 50 or 60 into the gallery in my courtroom. The idea of having several hundred people is just amazing, and it's great access. But again, it also means that when we're live streaming, everyone else can see you as well. So keep that in mind of what is showing. Overall, before I kick it to Jessica to talk more about some of these technical aspects, my overriding message is before the hearing, think about what you would do if you were standing in the courtroom. What do you want to accomplish? How would you present it? How would you look? How would you dress if you were presenting in a courtroom and standing here live and in person. And that's the approach that you should take when you are presenting in a video conference. So with that, I'm going to turn it over to Jessica in the interest of time and have her pick up with some of these technical issues. Jessica?
Thank you.
Judge Jamo, actually, we did have a question before Jessica gets started. What are your thoughts on the use of headphones during a hearing, both for auditory and for
headphones?
microphones?
That's a good question. Headphones, I think, are a good idea. We do see quite a variety and variance in the caliber of audio. Different computers, like the laptop I'm on now, it is harder for me to hear than on some other devices that I sometimes do video conference on or take a meeting on. And so it is very helpful. It seems to increase the quality of the audio in both directions. And I don't find it distracting at all for me in terms of appearance of the attorneys. It is not distracting at all to have them have, say, the earphone devices like Jessica has on now, or the headset device. Ms. Smith, my law clerk, uses a headset device that, there you go, there's an example of it. It's quite helpful to her and to us in terms of the quality, and it is not at all detracting or distracting from your presentation as far as I'm concerned.
Thank you, Judge. We didn't have any further questions. Go ahead, Ms. Zimbelman.
All right, good afternoon, everybody. I'm going to go through a couple of the technical considerations that I found doing Zoom hearings. And I don't even know how many I've done now as an advocate. I have done one Michigan Supreme Court oral argument by Zoom, which was quite the experience, but I've been in trial courts all over the state since March. So I have quite a bit of experience doing this, and I'm always trying to tweak how my presentation comes across to the participants in the hearing. So these are just a couple tips that I found. I'm going to share my screen and refer to the handout. You should all be seeing the handout now. Let me make it bigger. There you go. Everybody can see that? So we're going to talk about lighting first. These pictures I took in the summer. I have a 3 seasons porch at home, and you know, while all this was going on, learning where I could best advocate from, I also had 2.5-year-old twins running around my house. So I had to find a place that was quiet, but also had good aesthetics. So these are a few pictures. For most of the summer, I worked on my 3 seasons porch against a blank white background, but lighting was really good out there because it was surrounded by natural light. And the most important consideration when you're looking at lighting is that you want the light behind the camera, not behind you, because that's what happens. And you can see in this first picture here, when you're backlit, that's what you're going to see, is you're going to see a lot of shadow. Or here it's just poor low lighting, so I come off more fuzzy. And then here the light is coming from my side, so one side of my face is in shadows. So this, ignore the background, but just from a lighting perspective, I had natural light coming in from behind me. Now that it's winter and I can't work on my porch, I have moved to my basement. And I have a ring light behind my computer right now. And I have found that there's relatively good lighting in my basement, but just to have that extra push of lighting from behind my computer, behind my camera, makes my appearance better on screen. Backgrounds. Judge Jamo talked about, yes.
You had mentioned a ring light. What do you mean by a ring light?
So a ring light, I can put a link. I don't know if I can do that right now while I'm screen sharing, but I can provide a link to Chris to provide to participants. But it's literally a ring of light that plugs into my computer, and I can change how bright it is. I can change. So that is more of like a fluorescent light. You can do like a bluer light, a warm light. This is the one I go with. but then you can make it brighter or dimmer. So it was like $60 on Amazon, but I have found that it makes a big difference in how I appear on screen, which, you know, as advocates, we know that the better we think we look, the more confident we are in our arguments. So I do think that being visible to a judge, especially when we're not in court and the judge might not be able to read the same body cues, all you've got is your face. So you want to make sure that, you know, and to help out court reporters too, that it's clear, and good lighting really helps that. Backgrounds. So the best background are neutral backgrounds. And Judge Jamo mentioned this with virtual backgrounds, that not all virtual backgrounds are the same. And here you can kind of see a funny picture that I took of myself with a virtual background. Because when we first started all this, they were all the rage, and I was trying to figure out how to make it work in my own home. And I just couldn't. You know, that they're best if you have a blank wall behind you or a green screen. But they're just, in my mind, they're risky. They also use up a lot of your internet. So your connection might suffer because of that. This background here, you can see my husband's singular victory in deer hunting is on our wall. I am from Montcalm County, which is a very rural town. You know, do I want the world and judges to know that somebody in my house is a hunter? Not necessarily. That reveals kind of a lot about me as a person, and it's distracting. You can see an open door, you can see my bookshelves, you can see the ceiling. So that background is just too distracting, and as humans, it's going to be natural for us to look at what's behind people, especially when we get glimpses into their home. So I think that's kind of funny. This background, you know, I think there's a lot going on. You can see a table, you can see an open door with light just blaring through there. Early pandemic, this was where I would do most of my work. This one on a couch with the check mark by it. I think it's very obvious that I'm on a couch, and I didn't love that. But early on, that was my best option. I'm in my basement, as I said, and I ordered this just recently, this screen. Again, I got it from Amazon. But I think this makes me feel more comfortable, that the rest of the world isn't going to see my basement. It helps me control my own lighting. And it basically looks like a virtual background to me, but it's not. So you don't have those same problems. So this is kind of where I'm going to be for the time being, is this basement. I use headphones because my basement workstation is directly under our playroom. So those adorable 2.5-year-old twins that I talked about earlier, I can hear them running around upstairs. And I think if I didn't have headphones on, you all would probably be able to hear them as well. So, you know, you have to be cognizant of all this, which can be really overwhelming in a really overwhelming time. Let's see, I can kind of talk about the need to eliminate distractions. I'm going to stop screen sharing now until we need to talk about more pictures or show you more pictures. But, you know, it is really important to try and eliminate distractions as much as you can. And that can feel virtually impossible. But there's all sorts of distractions that we can have when we're arguing from our homes. You know, you've got kids running around, you've got pets running around, you might have adult roommates or partners who are also working and needing to do Zooms or use your internet. You could have laundry going, dishwashers going. I mean, there's just, our homes were not built for being lawyers. So as much as possible, when you're going to court, you need to eliminate those distractions as much as you can. You know, if you have a pet, have a chew toy ready. Work with any roommates or other adults in the house to make sure they're not online and using your internet speed when you're in court. So that, you know, there's really a need to try and eliminate those distractions as much as you can. With that said, though, most courts and people are very understanding if there's interruptions. You just really want to try and minimize them as much as possible for your own sake too, so you can actually concentrate on the advocacy at hand. So we're going to talk a little bit about framing now. Let me share my screen one more time here. This is one of the most probably common mistakes I see when I am advocating in court is the angle. So you really want your eyes to be level with the camera. Whatever camera you're using, you want your eyes to be level with that. Because, you know, here's an example again of my former spot on the couch. If it's too low, it's just not a great angle. Here, you see this often, this bottom page where I'm reading from notes and I can't tell that I've cut off my mouth, you know, and that's not an effective way to advocate when a judge and a court reporter can't see half of your face. So you really want to try and be cognizant to have that at eye level. I had to buy a riser for my laptop, which is what I use because it has the best camera. So I had to buy a riser so I could get it up. I also used a stack of books for a really long time. So, you know, just get that camera up so it's eye level, and the difference is really remarkable just by raising the camera a little bit. You know, these are some kind of, I don't know if you've all heard of Room Rater, or it's called Rate My Skype Room. It's on Twitter. It's very funny. And they literally grade people's backgrounds on what they look like. And you can kind of see, and it's ever since I've been doing these trainings on Zoom Court, I've loved watching the evolution of certain people who are on the news a lot, because they're putting so much thought into what they see or what they have in the backgrounds of their homes. And it's my personal belief that we should be spending just as much time, maybe probably not just as much time, because I'm sure there's people helping these famous people set up their backgrounds, but it's all part of advocacy. And to be an effective advocate, we really want to put thought into how we're coming across on the screen. There's a lot of information, again, about some technical things and different things that you can do. A lot of these tips can be found by watching Zoom tutorials as well. But just a couple of things, you know, that Judge Jamo touched on and that I've seen as well is you want to make sure that your name is appropriately displayed. Sometimes I will put attorney for so-and-so after my name. You know, that usually doesn't show up because it's long. But if there is a question about who you are, sometimes that information will be helpful. And I know it's helpful to clerks to have yourself properly named before you join the meeting and to have our clients properly named as well. You want to know and be cognizant of how to use your microphone and your camera. I think you're all here very cognizant how to use the camera, because I don't think anybody's showing right now, which is usually, you know, the easiest way when you're listening to a presentation, especially one during lunchtime. I hope at least some of you are eating lunch off camera. But you want to be aware of when your microphone is on and when it's off, and when your camera is on and off, because I have seen a lot of people on Zoom meetings and in court walk around with their camera on. And I mean, we've all been there, like, whoa, you know, that it's just, you know, it can make you very dizzy to watch that happen. Or your microphone's on and you are talking to your roommate or your children in the middle of a court hearing. So it's just, and of course, how many times have we heard, you know, you're still on mute, you're still on mute. We all do it at least once or twice in a meeting. So, you know, just be comfortable turning your camera on and off, your microphone on and off, and make sure your clients know how to do that as well. I'm kind of in a different frame of mind because most of my clients are incarcerated, so those same considerations don't exist. But especially for those of you who have clients who are on probation, or those of you with civil clients, all of these tips should be told to your clients as well, to make the best impression that they can. There is information on page 6 of the handout about how to hide self-view, and that goes to Judge Jamo's point about not using Zoom as a mirror. it's natural for us to look at ourselves when we're on camera. That's just instinct. So there is a way, and it's outlined in the handout, how to turn that off so you won't see yourself. It's pretty weird. I don't do it very often, but I have wondered if perhaps I should start doing that, because it would make you more likely to look at the camera, which is where ideally you want to focus on, because that would make you straight on for most of the recipients when you're talking. Screen sharing, that's something that you're going to want to practice with. Maybe Judge Jamo can talk a little bit more about his experiences with litigants sharing their screens to show exhibits. I'd be interested to hear what he has to say about that, but that's a function. Again, it's outlined on page 7, how to do that. My best tip for when you do share your screen as an advocate is to have nothing else open on your computer except the screen you want to share, because all your tabs will come up, and so the court will see everything that's open on your desktop. And there's on pages 8 through 9, there's a checklist about things to kind of think about, and it's a lot of these tips that are just pulled together into a checklist form, but it's things you want to think about as you're advocating. And I wanted to share one more picture from the handout. It's the last one on the handout. But this was Judge Jamo was talking about a lot of people watching court proceedings, but there could be a lot of participants in any singular Zoom hearing. And I think that this was a bond motion. You can see I'm on my couch here. This is early pandemic. And this was a bond motion at Frank Murphy Hall of Justice in Detroit. So it was a little more full. I mean, courts were also learning at that point in time. And now they're seemingly scheduling more specific times for one hearing, whereas before there might be a big motion call and a lot of people are there. I think a lot of courts are moving away from that particular thing, but there can be a lot of people in one hearing. I'm sure, I can't speak to the civil side. I'm sure that happens in the civil side. But this kind of shows, how important it is that you speak slowly, that you have a good background, good lighting, so you can set yourself apart, because there's very little opportunity for the judge to read your body language. So the oral presentation is really important, and just to make sure there's nothing distracting as a judge tries to squint at your background to see what's that deer hanging on the wall or something. So that's all I have from a technical point of view. I would be interested if Judge Jamo could talk a little bit about screen sharing, if that's something you like, dislike, if it's done. But other than that, I'll take any questions after that.
Sure, I will. I'll talk a little bit about screen sharing. First, I want to touch upon Jessica's point about body language being, not being able to have the full impact of it by being in court versus video conference. That ties in a little bit to what I mentioned earlier about attorneys not letting themselves get so relaxed and comfortable that they're in their own home or office, that the only body language the court gets is that you're laying halfway back in a chair, really not interested in the hearing or not having respect for the proceeding itself. So you don't want that to be your body language that is communicated. But Jessica is right. It is that is one thing that is different from the court side, is just being able to see the head part of it, the shoulders and head, and not getting what we all sort of rely on as advocates and litigators in terms of actually being in court and making the presentation the way we normally would. Screen sharing, the only thing that I would mention about screen sharing is if you are comfortable with doing it, and again, as Jessica said, at least for me, and I think this is probably universal with other judges, we all understand that there are going to be some glitches and problems, and things aren't always going to connect right at the point that you want them to connect, or when you try to screen share, something there might be a glitch or something that happens. And we all need to be, at least I try to be patient about that until we can straighten out the technical issues. But a couple of things, and I think Jessica pointed it out in the materials, the handout is, don't have a lot of miscellaneous things. When you flip to your screen, you don't want all of your icons or notes or whatever it is up. You want to make sure you're only sharing the document that you want to share. But the other thing is, try it ahead of time in terms of how does it come across on someone else's screen, because one of the things that I have seen happen is that the lawyer is proficient at switching over to screen sharing and getting the document up, but then the document is not of a size that I can read because of the size of my screen or whatever it is, or the way it's showing up on their screen. So make sure that you try to have it as a full-size document that will be readable on the other side to the individuals who are seeing it on their screen. And the other thing, touching upon something I mentioned before, as far as exhibits or demonstrative aids and sending them ahead of time, unless it's something that comes up, that just happens to come up during the hearing and you realize you need to use it at that point in time and you have not anticipated using it, it is always a good idea, I think, to go ahead and email that ahead of time to the other side and to the attorney, to the judge beforehand, so that in addition to you sharing it on your screen, if they want to, they can actually pull it up on their email or have a hard copy of it if for some reason it's not displaying in a readable format on your screen share. So those are just some things to keep in mind with screen sharing. One of the other things that I want to mention that is sort of buried in all of this is that among the technical aspects, a couple of things we have seen. Jessica's right, in civil cases, you're probably more likely to have multiple folks on the screen when it's a multi-party case with lawyers for each of the different parties. So it does change depending on what the court's view, if it's a gallery view or speaker view or whatever they choose. It can change what is coming across on the judge's screen. And also from a technical perspective, we have found that there are some devices out there that have unique glitches in terms of connecting to Zoom, especially the audio part of it. First of all, check with your judge as to whether they will allow your client, say in a criminal case, to be at a different location than you are at the time of the hearing, because there may be reasons why your particular judge wants you to be together with your client and not have to deal with, for example, having a client who's not proficient at participating from a technical perspective, proficient at participating in a video conference. And one of the things we have seen is that for some reason, some Galaxy phones are challenging to connect the audio, and there's some, I'm not sure we fully figured it out. We usually work our way through it. Ms. Smith, my law clerk, usually helps us figure out with the attorney how to get that put in place. But for some Galaxy phones, there's a particular prompt that comes up that the client will need to know. They need to hit that prompt on their phone, or they will never connect to the video conference audio. So work those things out with your client ahead of time. Make sure they're able to connect if they're going to be at a different location, if the judge permits the client to join in from a separate location.
Thank you, Judge Jamo. Do either of our speakers have anything to add, or I can open it up for questions at this point?
I'm good with opening up to questions.
Me too.
All right, everyone. So we have Jessica has shared her ring light and her background screen that she uses. Did anyone have any questions for either Jessica or Judge Jamo? Remember, you can either put them in chat, or at this point, if you would like, you can go ahead and unmute yourself and ask your question. You can turn your video on if you'd like as well. Just remember that we are recording and everything will be included in the recording. No one is jumping at the opportunity right now. Judge, I will just ask a procedural question. Have you seen it where unexpectedly there needed to be a document used to impeach that was not expected? Would you prefer if that was emailed over or just shown to the parties first? And I know this isn't a concern with juries right now, but if that was being done, do you need it to be emailed over to opposing counsel first, or can they reference it?
Right, that's a good question and a unique situation. That obviously, if we're going to try to stay as close to procedure that you would use if you were live and in the courtroom, it would not be broadcast universally in terms of the context, because obviously you would have them read that part of it. The witness would read that part of it. So if you know ahead of time, I think the best approach is to go ahead and email that over to the other side. The problem, of course, is you're not going to know that always ahead of time. So I think that's an appropriate place to stop and ask how the judge would prefer to handle it at that point in time. You might just be able to reach agreement with opposing counsel as to how we do that, whether that becomes, if there's not a jury and it's just a bench evidentiary hearing, whether that becomes a screen shared document or how that would be handled.
Thank you very much. We did, there's a follow-up question on the judge's copy. Do the judges prefer paper copies to chambers or emailed copies to chambers, or both?
I think so far what I'm hearing, at least from our bench, is paper copy, unless you communicate with the judge's office, the judge's law clerk, or judicial assistant, and get instruction otherwise. But at this point in time, at least as far as I understand, and for me, and I know for Judge Dragonchuk, that it is paper copy that actually gets right to the judge's chambers. One of the things that is going on right now is the clerk's office, I don't know if they're still doing it. For a while, they had a drop box when we were trying to limit the number of people in the building and moving about the building. And still, in general, there is, the hope that we don't have extra people in the building. And that's one of the reasons the clerk still accepts emailed pleadings. But as far as the judge's copy, one of the challenges we've seen, Chris, is that as we all realize, mail transmission, regular mail transmission to Lansing, even from areas close to Lansing or even from within Lansing, are taking an exceedingly long period of time to arrive. I frankly think that we may, in the not too distant future, need to adjust the court rule with respect to timeframes. But parties mail things, expect they'll be here in a day or two, and sometimes they don't get here for a week. And in addition to that, we have the complication if they just land, say you mailed the judge's copy to the clerk's office, they may not get up to us before the hearing. We may not realize that they're there for all kinds of reasons, staffing reasons during the pandemic in the clerk's office, lots of reasons. So the preference is that you figure out how to actually get the hard copy to the judge's chambers in time for the hearing. One of the reasons that I think, Chris, it is confusing for practitioners that they can email pleadings to the court clerk is that there is an assumption perhaps that once that happens, it is, first of all, it is true that when they get it, we are converting to electronic, the pleadings are being scanned in the clerk's office. So we're not an electronic filing court, but we're going to electronic documents within the court. But the problem is you can't tell, and we don't know when they will be scanned in. So it's not necessarily true that when it hits the clerk's office, that immediately as a judge sitting up on the third floor, that we can on our computer pull up the file and see the document scanned in. It may not be scanned in right away, and we don't know it's there. So between the issue of us not being an electronic filing and therefore still needing a judge's copy, and not being able to necessarily immediately access whatever is being scanned in downstairs, you really need to get a hard copy to the chambers, the judge's chambers.
Thank you. And I'm not going to ask you to speak on behalf of all judges, obviously, just your own personal preference. But with the Zoom hearings happening, sometimes it'd be advantageous for us as litigants to have a recording of it. Is it possible to ask ahead of time for the court permission to record it via Zoom? Or does
That's
it
what
need
I
to
would
be?
do. I would
Okay.
ask ahead of time to do it. It's a really interesting question, and one probably that would take too long for us to discuss and perhaps debate here in terms of recordings when they're, because some of us are broadcasting, like mine are streamed, but they don't stay up. It's just as if you were to walk into the courtroom and observe a hearing, you observe it on YouTube. It's for the most part gone, unless we had some sort of glitch in live streaming it, then we typically will post it. Other judges are posting it for a period of time, which obviously either way, live streaming it or posting it also allows other people to make recordings. And so it raises this issue of things that might not be able to be recorded if you were actually sitting in the courtroom, but now are out there on the internet to be able to record or post. So from my perspective, I would simply contact my law clerk or my judicial assistant, say, hey, I'd like to record this for whatever reason. And in most circumstances, I don't anticipate that for me to be a problem. But again, I would check with each judge's office.
Absolutely. And would you want us to reach out to opposing counsel or other counsel at that time
Yes,
prior to that?
Surely, because then you can obviously say there's no objection to it.
Okay.
And we can think of, obviously in your practice, Chris, we can think of things that might not be, like if there was some sort of an evidentiary hearing that involved a minor or some sensitive information, or that is being presented in a protective way, there may be considerations there. So obviously, an agreement presented is always better.
And that actually segued nicely into a further question. Is normally in court with displaying exhibits, showing them to the court, even in open court, the parties in the back are not going to see everything up close in detail, for instance, sharing photographs, things like that. Do you have a general guideline of all exhibits should be displayed with screen share, or is it, an exhibit only should be displayed if it's necessary or the parties don't have it?
I don't have a guideline on it. Again, I think it depends. It's situation specific for me in terms of what is being displayed, because obviously in some cases there are sensitive materials, photos, certain types of photos. And as you know, say during a jury trial, you might put it up, but only briefly, or you might agree not to put it up. So I think those same rules would apply. I don't necessarily, as a general matter, I don't necessarily think that it needs to be screen shared. For me, if you have presented it in the way that I suggested, that it is emailed in, if you know you're going to use it, and or at least you know you're going to move for its admission, email it so that we can mark it. One of the advantages is that if the court reporter then marks it, and what we have been doing is emailing the marked exhibit back to everybody. So you actually have a copy of the stickered exhibit with the mark, exhibit 1 or exhibit A, whatever it may be. And then we all can use that same terminology in the hearing, referring to it as exhibit 1. And then if I have it in front of me to look at in that form, I don't necessarily need it to be screen shared.
Great, thank you very much. Were there any further questions either for Judge Jamo or Ms. Zimbelman? Remember, you can unmute yourself or put them in the chat. All right, I am not seeing, someone unmuted themselves. Oh, Jessica did.
I was going to say bye.
Thank you so much. Thank you both so much for your presentation. We appreciate it. This will be stored and saved online. So thanks again, Judge Jamo and Ms. Zimbelman, for your continued service to the bar and your wonderful presentation today. If you have any questions, ideas for future educational events, feel free to email me, cwickman, CWICKMAN, @nicholslaw.net. Thank you to everyone, and the chat is also saying thank you as well. So I will go ahead and stop recording, and thank you again, everyone, and have a good